Welcome, everyone. I'm going to go ahead and get started because we have a unusual, a different, a really exciting speaker today who is here as part of our university's annual program on Holocaust, genocide, and contemporary bioethics. This program takes place over the congressionally designated Week of Remembrance of the Victims of the Holocaust. It's a pretty unusual. At the time we started it a few years back, it was really a very unique program. There were none others like it, where we spend some time remembering and reflecting on the role of health professionals in the Holocaust and how that legacy, that history, continues to influence the ways that we think about bioethics, about medical policies, health policies, public health. And we have really become a model, I think, for many other countries, many other institutions, not just in the US, but around the world, in having these kind of remembrance opportunities and events. I think one of the reasons that people have copied this is because we really focus on bringing this history forward and seeing how the legacy of the medical crimes committed during the Holocaust have influenced today. And our speaker today is really uniquely suited to doing this task with us. Professor Philippe Sands is an acclaimed author, and you'll maybe recognize some of his books. He has a recent one out called The Rat Line. Before that was a book called East West Street. And he has traced the legacy of the Holocaust forward to its role in creating modern human rights law. And as you probably know, many of the crimes of the Holocaust were medical crimes. And so medical crimes of the Holocaust have come to influence the way that the legal system looks at criminal cases in the international arena. And Professor Sands is, in addition to being an author, an active barrister. So he has been involved in one way or another in the prosecutions of essentially every major international human rights case that you will have heard of for the last 20 or 30 years, from Pinochet to the Rohingya, from Rwanda to Ukraine. And he, in his books, has really deftly woven together this history of law and justice and human rights violations with his own family's history, which is just an astonishing feat, honestly. So I urge you to read his books. And I'm going to turn things over to him. But first, I must thank, we don't have him up anymore. The slide that was up before showed the many sponsors that allow us to continue this program. It was started with a generous gift from Dr. Bill Silvers, who's here with us today. And it has subsequently received funding from the Rose Foundation, from Jewish Colorado. We have a very valuable partner in Physicians for Human Rights. And our program has been at various times also in partnership with the US Holocaust Memorial Museum and other programs around the country. So we really appreciate all of the partners that it takes to bring this kind of program together. It's a program that not only touches the medical campus, but tomorrow we will be up at the law school doing a similar program about the legal history and ramifications. So without further ado, I'd like to turn things over to Philippe Sands. Thanks so much.
Testing. Excellent. Okay. Firstly, it is very nice to be here. Thank you so much for the invitation. Thank you for those who have been supporting this happening. I'm also a university professor at University College London, and many of you will, I'm sure, know my colleagues from the various medical and science schools. I'm actually at the law faculty, but I do have a lot of interactions. I was very pleased to accept this invitation because in the fields of work that I do, teaching and the practice of law, litigating cases, and writing, the role of the medical side of science is pretty central, and comes up in most of the cases that I'm involved in one way or another. I was telling Matt an example of one in relation to Pinochet that I'm involved in right now as I write up events from more than 50 years ago. What I want to talk about today is how these international crimes and concepts, which are now very familiar to you, came into being, and how they impact I'm going to tell you one story, the medical community in dealing with an issue that is very current today and in which I'm involved. If you go back to the 1940s, there was but one international crime. This is sort of lesson 101 on international crimes. It was war crimes, which dates back to the 19th century and which describes acts committed during war which are unacceptable, targeting civilians, including medical practitioners in times of armed conflict, has been forbidden and unlawful. But when the Second World War started, that was pretty much the only statute, the international crime, that was on our international statute books, treaties, and general international law. During the famous Nuremberg trial, in the run-up to it, 3 new international crimes were essentially invented and came into being to deal with the horrors that were faced at that particular time. One of those crimes was crimes against humanity, which concerns the harm caused to individuals on a significant and widespread scale. A second crime was the crime of genocide, the destruction of groups rather than individuals. Keep that distinction firmly in your minds. And the third new international crime was then called crimes against peace, today the crime of aggression. That's very much in the news right now in relation to Russia's invasion of Ukraine. I studied these crimes in the 1980s at university here and in the US. And then as I got into my academic life, became involved increasingly in this area of international law, that's my background, and was, for example, one of the negotiators of the Rome Statute of the International Criminal Court in 1998, but also increasingly became involved, as Matt has said, in a number of cases. And so my life by 2010 was steeped in international criminality of various different kinds, intersecting obviously with professionals, with victims, with perpetrators across the board. Like you, I meet some remarkable and some truly ghastly people. And in 2010, in April, and I should say also, well, I'll explain it then in this order, I received an invitation out of the blue that invited me to deliver a lecture at the University of Lviv in Ukraine. I didn't know where Lviv was. They wrote to me, I got an email, more or less like yours, would I come and give a lecture on the cases that I do on crimes against humanity and genocide? I did a bit of Googling, discovered that Lviv is the same place as Lvov, Polish name, Lemberg, Austro-Hungarian German name, Leopolis, Italian name, Lvov, Russian name. It's all the same place. My grandfather happened to be born in Lemberg in 1904, but he never talked to me about what happened because his entire family from Lemberg, about 80 individuals, were murdered in the Holocaust. And it was a very, he lived until 97, I knew him very well, but he never once talked to me about anything that happened before 1945. So I thought, that's interesting. I'll accept the invitation, not because I had a burning desire to give a lecture, but because I wanted to find the house where my grandfather was born. And so began an adventure which I'll share parts of with you right now. I went to Lviv. I'd done a bit of research in advance, and I found the house where my grandfather was born, which was important to me. It helped me understand more about who my grandfather was, and it helped me understand more about my own sense of identity. But I made two other discoveries that absolutely surprised me and are the subject of the book East-West Street, and the reason that I get many invitations, and many invitations from the medical community, particularly psychiatrists, psychoanalysts, psychologists, for reasons you'll understand momentarily. The first thing that I discovered was that the man who wrote this book, An International Bill of the Rights of Man, published by Columbia University Press in the summer of 1945, the first ever textbook on international human rights law, the font of our modern system of international human rights law, that later got taken up in the concept of modern human rights and the Universal Declaration on Human Rights. Hersch Lauterpacht, who coincidentally was the father of my first teacher of international law. Here you can see an image of him in his garden in Cambridge. His central focus in law was the protection of the individual. That's the fundamental nature of human rights. His thesis was that every human being, every sentient person, irrespective of origin, creed, politics, color, nationality, ethnicity, whatever, had minimum rights under international law. And that was a revolutionary idea in 1945. And it's still, as you know, a contested idea today in this country and in my country, where there is a rollback going on in terms of many of these ideas. But he is also the man who invented this term. Here you can see it in his own handwriting, crimes against humanity. In June 1945, he was working with Robert Jackson, who he'd started working with in 41, 42, on the drafting of the Nuremberg Statute, and it was he who came up with the formulation crimes against humanity, attacks on individuals on a systematic and widespread way. What was striking about this guy is that remarkably, he was a student at the University of Lviv from 1915 to 1919. And folks who invited me had no idea, as I didn't have any idea when they invited me, that he had a direct connection with their own university and law school. He left in 1919, he went to Vienna, he studied with a famous professor in Vienna, and then ended up in London and at Cambridge University and became a prosecutor at the Nuremberg trial. The curiosity, totally accidental, I wasn't looking for it, was that the concept of crimes against humanity has its origins in the city of Lviv. So I thought, that's pretty amazing. I'm going to turn up there and, you know, they'll be pretty thrilled to learn that having invited this fellow from London to give a lecture on the origins of crimes against humanity and genocide, they actually originate in their region, in their city. We found the very building in which his teacher actually encouraged him in this direction. The context for his work on human rights and crimes against humanity was that in the period 1915 to 1919, the city of Lviv, which had a population in roughly equal numbers, Poles, Jews, and Ruthenians, as they then used to be called, today Ukrainians, would every time there was a change of government, which was very often, 8 changes of nationality in the space of just 20 years. Imagine November 1918, in the first week, it was Polish. In the second week, it was Austro-Hungarian. In the third week, it was Ukrainian. In the fourth week, it was Polish again. And I've always wondered what a teacher of international law does, or a teacher of domestic law does every time, the governing country changes. But each time there was a change, there was a huge amount of bloodshed. And what Lauterpacht wanted to do was to find a way in which you could embrace a rule of international law which would offer protection to human beings in times of turmoil. And his thesis was, you do that by recognizing that every single human being has minimum rights under international law. At the time that he invented that idea, revolutionary, imposing obligations on all states, the situation was that under international law, if a sovereign, a president, a government, a prime minister decided that everyone on this side of the room tomorrow is going to be executed at 6 p.m., international law said, well, that's your prerogative. They're your people, you can do whatever you want with them. We don't provide any protections. It seems self-evident today, but in 1945, it was a revolutionary moment. But the key point is, his thesis was the protection of individuals. There was a contrary thesis. And the contrary thesis was put by the person who wrote this book. Axis rule in occupied Europe. Raphael Lemkin, some of you may know the name. Remarkably, almost unbelievably, he too was a student at the University of Lviv. After Lauterpacht, from 1921 to 1926. And Lemkin's claim to fame, you can see him here. By 1945, he'd moved to the United States, and this is his identity card from the United States Department of War, was that he invented this word, literally invented it. He too was a student at the University of Lviv, not at the same time as Lauterpacht, as I mentioned. And his thesis, contrary to Lauterpacht's thesis, invented at the same moment, he predated it by a few months, November 1944, his book was published, was that Lauterpacht was wrong. You should not focus on the protection of individuals, because in times of conflict, human beings get targeted, not because of what they have actually done as individual human beings, but because they happen to be a member of a hated group at a particular moment in time. And so Lemkin's thesis and the idea of genocide is not to focus on the protection of individuals and give rights to individuals, but give rights to groups. Protect the group, the ethnic group, the national group, the religious group. And in that way, by protecting the group, you will protect the human. So these two ideas, which you will read about in your papers now more or less every day, come into being in 1945 at London Conference, where the Statute of Nuremberg is signed and adopted, and then creates the famous Nuremberg Tribunal. Both terms come to life in the famous Nuremberg trial, 1945-1946. Both men are involved in the prosecutions. Lauterpacht with the British prosecuting crimes against humanity, Lemkin with the Americans prosecuting genocide, and there is a fundamental tension between the two of them. Lauterpacht does not like Lemkin's idea. Lauterpacht's thesis is that if you focus on the protection of groups, you will replace the tyranny of the state with the tyranny of groups. And right now, in the United States and in other parts of the world where identity politics is rampant, you can begin to understand the context of that thesis in a modern way. All very well, says Lemkin, but the reality is that is how horrors are perpetrated. And if we don't protect the group, we undermine the well-being of the individual. Both terms get used at Nuremberg. Both terms are then adopted by the United Nations General Assembly in 1946, and both terms become part of our international legal order and have done ever since. Nothing much happens for about 50 years. And then in 93 and 94, you get the horrors of Rwanda and Yugoslavia, and both concepts come back to the fore. And ever since, there has been a humongous battle between those two ideas. Now, those two ideas form the basis of the kind of work that I've been involved in. The essential difference between the two ideas is that if you kill 10,000 people or 1,000 people, it is almost inevitably going to be a crime against humanity. But will it be a genocide? Proving genocide is more complex than proving crimes against humanity for the following reason. Crimes against humanity, all you have to establish is that person A was involved in some way in the act, for example, of killing a large number of human beings. Is the killing of a large number of human beings an act of genocide? It's only an act of genocide in law if you are able as a prosecutor to prove the intention, the mental intent to destroy a group in whole or in part. And that has proven to be very, very difficult because generally mass killers don't leave pieces of paper around saying, oh, and I'm going to kill this community in this town or in these towns in order to destroy a particular group. You're left to infer intention from a pattern of behavior, and that's extremely difficult to prove. It's much easier to prove crimes against humanity. And now we get to a central problem of our times, which is that for various reasons that are not yet fully understood, if you are part of a victim community which is on the receiving end of some series of acts of horror, victims want what has happened to them to be characterized as a genocide, not as a crime against humanity. Because in popular and public consciousness, but not in the legal community, a genocide is seen as the horror of horrors, the crime of crimes. I don't draw a distinction between war crimes, crimes against humanity, or genocide. Whether you kill 10,000 people and put the label on it, genocide or crimes against humanity, makes no difference to me. But prosecutors at the international tribunals and in national courts will tell you victims want the label to be genocide. I've been very skeptical about this issue of labeling and very concerned about it. It gives rise to a lot of problems. For example, in relation to the 1915 killing by the Ottoman Empire, the Turks, of large numbers of Armenians, there's no dispute that huge numbers of people were killed. The dispute is only about the question of what label to put on the act of killing. And Turkey says, with some reason, today it's a big issue in Turkey, that when these terrible acts happened in 1915, the word genocide had not been invented. How can you apply retroactively to 1915 a concept that was only created in 1945? And that argument has some legs. And so you get this massive dispute that distracts from the basic facts and becomes a dispute about terminologies. And that's very current today. Some of you may remember that about a year ago, President Biden made a statement in which he said that he thought a genocide was taking place in Ukraine. A few hours, he cleared that up and said, well, actually, what we label these apparent horrors that are taking place at Bucha and at Irpin and Mariupol is a matter for the lawyers. I'm not going to get involved in that. Let's leave it to the lawyers. He basically, was not relying, should we say, on a full briefing. I was asked to do an opinion piece for the New York Times, which I did. I published the next day. And I didn't want to undermine the decent intention of what he was doing, which was to put the emphasis on the horrors that we were beginning to see on our television screens and read about in our newspapers. But I didn't want to support the idea that those horrors would easily be characterized in a court of law as an act of genocide, precisely because I think it's going to be very difficult to prove that what happened at Bucha or Irpin or Mariupol is motivated exclusively by the intention to destroy a group in whole or in part. It may be, but that's very difficult to prove. The bottom line of it is, over the years, I've become increasingly concerned about the way in which the concept of genocide has skewed the debate, leaving as a consequence the feeling that if someone is convicted only for a crime against humanity or a war crime, it's less important or it's less terrible. The bottom line is, if an American president says a genocide is happening, it'll be on the front page of every newspaper. If an American president says it's just a war crime or a crime against humanity, it passes in silence. That is not a socially useful thing to happen. So when I wrote my book, I was very surprised to get a large number of requests from parts of the medical community to address congresses and meetings and conferences. I think it was a different group from the group that's in this room. It was psychiatrists, psychoanalysts, and psychologists who were completely fascinated by this distinction between the individual and the group. I even did an event with the leading academic and practitioner on matters of public health in the United Kingdom, Sir Michael Marmot, who's just wrote me this email out of the blue. I didn't know him, just saying his entire life's work has been focused on the relationship between the individual and the group. And of course, your work also, in terms of bioethics and other aspects, is deeply informed by the choices you may have to make in particular moments in determining whether to prioritize the well-being of a group or of an individual, which raises fundamental questions of the rights of the individual of the group. I was blissfully unaware when I wrote East-West Street of what I was wading into in relation to this fundamental question for your community and for the community of medical practitioners in those fields that I've come to know. And I've spent a lot of time now with psychiatrists, psychoanalysts, and psychologists debating and talking things through. I remain of the view that the concept of genocide may indeed be wrong-headed, because it has firstly underscored this unnecessary and unhelpful debate that has tended to minimize war crimes and crimes against humanity, but also because I have in my own work observed that by putting the focus on genocide with the need to prove the intention to destroy a group in whole or in part, which intention you do not have to prove for crimes against humanity and war crimes, you actually reinforce the very thing that the invention of the term was intended to lessen, namely intergroup hatred. And I've been in rooms with prime ministers and presidents where we, the lawyers, have said, Mr. President, we don't think on the basis of the evidence we have, you can establish that this is a genocide. It's a crime against humanity, it's a war crime, but we don't think you'll be able to prove the mental intent. And this produces in the people who instruct us at the political level, feelings of anger, of irritation, and of greater hatred for the other groups. The classic example is former Yugoslavia. Bosnia gets a genocide for Srebrenica before the Yugoslav tribunal, but the same tribunal rules that what happened in Vukovar on the Croat side, slightly smaller numbers, but nevertheless, in my view, just as horrible, is only a crime against humanity. And today, 20 years later after those judgments, the fact of those judgments is reinforcing intergroup hatreds between those three communities. And it makes me ask myself the question, what is the social utility of the concept of genocide if it actually reinforces group hatred rather than, as Lemkin in his excellent intentions, sought to minimize it? So that was my feeling until about 2018, when I received a communication from a remarkable individual in Germany. This is a man called Dr. Jan Kizilhan. He's a psychologist, he's German, he's also of Turkish and Kurdish origin and himself of Yazidi origin. Some of you may remember that in 2014, in August, ISIS, or Daesh as it's called in the region of northern Iraq and Syria, went on a rampage and targeted in particular a community called the Yazidi community and killed tens of thousands of people and also abducted young women and girls in very large numbers, who were then taken to places unknown and basically put into programs of sexual bondage and enslavement. Some of you will have read about this. Jan Kizilhan, and I'd read about him in the papers, was the practitioner in Baden-Württemberg in South Germany who persuaded the government of Baden-Württemberg to give him a fund of 100 million euros to set up a program of rescue for medical and psychological treatment of the young women and girls who had been abducted. And he personally went to northern Iraq and Syria and personally identified the 1,100 individuals. I mean, the numbers are staggering. I mean, that's just the tip of the iceberg. But that was what he had a budget. And Germany then gave haven to these young women and girls, most of whom are still there today, putting them through an intense program of psychological and medical and psychiatric reparation for the terrible things that had been done to them. Out of the blue, I get a communication from him. I need your help. I need your help because part of my program of rehabilitation of these extraordinary individuals is to create in their minds the possibility that justice can be done, that some of the perpetrators might be apprehended and subjected to a criminal justice system, either in domestic law or in international law. So I went to Germany, I spent quite a lot of time with him, and I met a lot of these young women and girls. It is, looking back now on a career of 30 years of dealing with this, I think as traumatizing an experience as I have ever been through, to be presented with a room full of now 18 and 19-year-olds, but who describe having been abducted when they were 14 and 15 and subjected to rape and other physical and sexual abuses on a scale that is literally beyond imagination. I mean, it's beyond imagination for anyone. I happen to be a parent. I have 2 of my 3 kids were girls of that age at that point. And the stories they told me were literally beyond imagination. And he and they talked me through their own assessment of what they wanted in terms of justice. And what they wanted was genocide. They didn't want crimes against humanity, and they didn't want war crimes. And we had extensive discussions about this. I tried to explain to Jan that if you go the genocide route, it's going to be much more difficult to prove. And if you fail in some of these cases, the sense of distress and of loss and of failure and of repudiation, etc., will be even greater. And he just said, I don't care. I said, why do you care about genocide? What is it about the concept of genocide that is so important? And he described it as a medical individual in incredibly simple terms that changed my way I looked at these things. He said, Philippe, you have to understand. I get crimes against humanity. I get that each of these individuals has rights that are entitled to protection under international law. But the crucial thing for me in the program of treatment with them, having spent now 2-3 years with them, is to instill in them the feeling that society validates their right to exist as a group. That is the central beating heart of the program of rehabilitation for them. And crimes against humanity doesn't achieve that. Genocide is the only crime that achieves that result. So please help me put genocide on the table in order to allow these young women to feel that they are entitled to exist not only as individuals, but as a member of a community that the system of law recognizes is a group that is entitled to exist as a group. And the moment he put it to me in those terms, I, of course, completely understood. I mean, completely understood. And so there is still this fundamental tension between the individual and the group in law and in your areas, and it's not going to be resolved. They're in conflict with each other, they undermine each other, but the two are going to continue in law as they continue in your own practice. To draw my comments to a close in a rather positive way, in the face of this rather grim story, a German court has recently convicted of the crime of genocide one of the perpetrators in relation to these young women who happened to become a refugee in Germany, was identified on a Facebook chat. That's, I mean, imagine what that's like when you're one of these young women and you go on Facebook and you're in chats with people and you see who the friends are and who's on, and you spot someone who is it's that in itself is, you know, just thinking about that is traumatic, frankly. But in that way, they found one. They found one of the perpetrators. And he was arrested, he was interrogated, he was charged, he was judged, and he was found guilty of the crime of genocide. And Jan Kisselhahn's view is it may only be one person, but we now have a confirmation by a German court that we are entitled to exist as a group. And that has been hugely important in helping these young women to get to the next stage. Let me stop there because I wanted to very much to leave time for questions and conversation about any number of other issues, Ukraine or whatever other issues you may want to talk about, or particular issues where I've had to deal with medical practitioners. But I just wanted to set the context of how an international lawyer comes to these issues. Anyone who says to you these issues are black and white, simple, without complexity, it's just not like that. There are some situations which are right and there are some situations which are wrong, but it's an intensely challenging and complex debate, and reasonable people can have different views and different conclusions, and one has to be very respectful about that as we go forward. That's the context I wanted to leave you with, and maybe now we can just have questions and the discussion that people would like to have.
Thank you. I'm going to take the moderator's prerogative and ask the first question, because I'm dying to reconcile the Declaration of Independence and what you said about the brand new concept that all men are created equal and endowed by their creator with individual human rights, right? So had that idea was that uniquely American? Was that something that hadn't...
Magna Carta.
Yeah, exactly. So I want to trace this back a tiny bit more.
So here's the difference. That is a development in domestic law. And French Revolution and the rights of man and Magna Carta deals with limits placed, in the case of Magna Carta, on the king or the queen, on the Declaration of Independence, on the president and the executive, under domestic law, okay? And domestic law can always be changed domestically, and that's it, you're free to kill or do whatever you want to do. The revolution that happened in 1945 is that it jumps to the international level. And the president, the king, the prime minister is subject to constraints not by the domestic legal order, but by the international legal order. And that's what is so controversial in the US context, not so much in the European context. The idea that, we're subject to rules created outside Washington or outside our own state governments that could impose limits on us. This came up in 2002, 2003, in the so-called War on Terror, when the United States moved to the practice of torture. Okay, and if you look at the legal opinions of people like John Yoo, sorry to say, still teaching at University of Berkeley Law School, the central thesis is we can bypass these international obligations because they don't really limit what we do. All we're going to apply is domestic United States federal law, and we've found a workaround that allows us to do waterboarding. What Lauterpacht and Lemkin and many other people wanted to do was to impose a higher set of norms from which individual countries could not derogate, even in situations of national emergency, to stop these kinds of practices from taking place. That's the heart of the difference. It's a big difference.
Thank you so much, Professor Sands. Is it possible, though, that actually international human rights can be derived from the 1924 Geneva Declaration on the Rights of the Child, which was adopted by the League of Nations? It certainly doesn't take you into the criminal construct that used as your point of departure today in 1945, but actually that international framework arguably could be derived from that international instrument.
Absolutely. I mean, the critical moment is 1945, because that is when, for the first time, you get a United Nations, you get a set of rules from Nuremberg, you get the Geneva Conventions, you get all these new international rules. But of course, they didn't just pop out of nowhere. If you read Lauterpacht's book, An International Bill of the Rights of Man, you'll see that his ideas, and Lemkin's, are inspired by the Declaration of Independence, the French Revolution, Magna Carta, and developments from China and other places around the world, and some international developments. I think that instrument of 1924 is essentially about child labor. Does it go further? Okay, then I'm not. Yeah. But essentially, you can follow the path through domestic law to first dealing with sectoral issues. I mean, I'll have to look into it. I don't know that instrument well, but the major instruments, of course, on the Convention on the Rights of the Child is not until 1989. And I don't know whether that instrument of 24 went very far or whether it imposed binding obligations. But irrespective, the point is all of these developments in the Treaty of Versailles, your 1924 instrument, fed into that 1945 moment until a broader generalized set of rights was created. So it started at the national level, begins to percolate upwards in sectoral issues, children, the employment of women, rights of minorities at the Treaty of Versailles, and so on and so forth. And it filters through, and people like Lauterpacht and Lemkin persuade governments to then have a generalized system. So it is all interconnected.
Sounds like, at least in part, they're sort of building the case that these are natural laws, that these exist across cultures, across communities, right? That
Well, that's
not exactly.
well, no, it is exactly, but I'm laughing because Lauterpacht had to imagine you're Hirsch Lauterpacht. You're teaching in the United States in 42, 43. The various US foundations give you a grant to write a book on what becomes an international bill of the rights of man. So Lauterpacht has a problem. Where does this come from? Where does this come from? There's no treaties. There's no agreements by states to grant human rights to every individual on the planet. So what he does is he digs into natural law, and he goes back to, Augustine and Thomas Aquinas and the religious instruments across the different religions to show there's a commonality of value. And he sort of invents the idea that across the whole of humanity, there are these minimum rights that all communities recognize and respect. And so they've suddenly crystallized into an international norm. The problem is he doesn't believe in natural rights, but he's got an agenda. He's got to persuade governments that this already exists and it doesn't require action by states to do it. And so natural rights is where he goes. But if you read him, it's a wonderful book. He's a very scholarly man. It's really worth reading the original 1945 edition, not the 1951 edition, because the 45 edition is the one before there was anything. By 1951, he's referring to all the things that came after Nuremberg and all of that. But the 45 edition is one of the great reads. It's really worth getting and having a read of it.
It sounds very reminiscent of what happens at the Nuremberg medical trial, where there's sort of an assertion made that there are ethics that govern human subjects research, and we all know what they are. They've never been written down anywhere,
Right.
but we all know what they are. They're obvious. They were so obvious they didn't even need to be written down.
So, this is the great elephant in the room for my world. And I look at it through the lens of a man called Hans Frank in my book, East-West Street. Hans Frank was Adolf Hitler's lawyer from 1928 to 1933. And he was recompensed with first becoming a Minister of Justice in Bavaria, and then from 1939, given the governor generalship of Nazi-occupied Poland, on which all the extermination chambers, Sobibor, Belzec, Treblinka are located. I mean, a really terrible individual. Although I've come to know his son, who is a remarkable individual, and we've become very close, actually. And Frank, of course, is indicted as defendant number 7 in the main trial. And because of his remarkable conversations with an American psychologist called Dr. Gilbert, and that is also worth reading if you're interested in this, the diary of Dr. Gilbert. He was the psychologist, but basically what happened was one of the 24 defendants at Nuremberg in September 1945 committed suicide. And so the prosecutors panicked, and they thought we'd better bring in some psychologists to stop these people from topping themselves, because we'll be left with none of them. And so they bring in a group of psychologists, a remarkable project. And one of them is Dr. Gustav Gilbert, who keeps a diary of all the discussions he has with the 22 defendants who remain. Martin Bormann never was caught, so there were 22. And it's an absolutely gripping read. It's really worth getting on a book secondhand and just read it through, because this comes up. Frank's view is this is outrageous. They have invented these concepts, which I'm now being indicted for: crimes against humanity, genocide, crime of aggression, crimes against peace. These didn't exist in 1939. These didn't exist in 1942. These were invented in June 1945 in London and retrofitted, if you like, back to the situation that pertained when all these allegations were taking place. And that violates my fundamental rights. So that becomes an issue in the Nuremberg trial. And of course, the judges sort of fudge it, because they have to fudge it. We've been given a statute to interpret and apply. We're going to interpret and apply the statute. But the reality is, it was victor's justice, and it was applied retroactively, which is problematic. So they were acutely aware of that, and that came up in the medical trials. It came up with the lawyers, as you can imagine, because there were then subsequent trials after the main trial, and the subsequent trials were not the International Military Tribunal, it was the US Military Tribunal, just as significant, just as important. Worth mentioning that the last surviving prosecutor from the US Military Tribunals, the wonderful, extraordinary individual who I feel so privileged to have known for nearly 30 years, Benjamin Ferencz, passed away last week at the age of 103. And he was totally compos mentis until earlier this year. I mean, just an absolutely remarkable human being. One of these people you just feel so inspired to have met. Tiny little guy. And if you go onto YouTube and look up Ben Ferencz, it's like a lectern like that. And his little head barely sort of looks above. And he was just, absolutely hammering them. And he devoted the rest of his life to this issue, including Ukraine. I was liaising with him on Ukraine just a few months ago. So the theme for your week is that the line from this period, 1945, to what's going on today is absolutely unbroken.
So how do you...
He's coming to you with a microphone.
I can speak loudly. How do you characterize the current behavior of Vladimir Putin regarding Ukraine? And does the label or language you use affect how other countries, or let's say an organization like NATO, how likely they're going to maintain their role?
So the day after the Ukraine war began, and it is a war, it's not a special operation, it's a war with all of its horrors. And I was contacted by the Financial Times to write an opinion piece, because I've spent so much time in Ukraine, because Lviv is in Ukraine, it's the font of many of these international crimes. They asked me to write 700 words on Ukraine and international law, which I did 2 days later, and I proposed the creation of a special criminal tribunal for the crime of aggression. You'll remember there are 4 international crimes: war crimes, crimes against humanity, genocide, the crime of aggression. The International Criminal Court has jurisdiction over the first 3. It doesn't have jurisdiction, for various technical reasons, on the crime of aggression. And as far as I'm concerned, the crime of aggression is the most important of the crimes. They're all horrible, but it's the most important, because if there had not been a decision to go to war, we wouldn't have war crimes, crimes against humanity, or allegations of genocide. Secondly, the crime of aggression is a leadership crime. It's only the top table. And so you go straight to Mr. Putin, Mr. Lavrov, Mr. Shoigu. The difficulty with war crimes, crimes against humanity, and genocide is linking what happened, for example, in Bucha to the leadership. That is really difficult to prove. We don't know what happened on the ground precisely. Prosecutors have to investigate it, and they want to draw that connection. You will be aware, because it got a lot of attention, that 2 weeks ago, the International Criminal Court prosecutor, Karim Khan, my former student, indicted Putin for the deportation of children. And to a certain extent, I welcome that. But, and here's my caveat, I have kids. The deportation of children is a horrible thing. He's been indicted for war crimes for that. They have more of a difficulty linking it to crimes against humanity. And he's been indicted with, I think, the children's commissioner in Russia for organizing this scheme of sending children. You probably know it much better than me. It's horrible, manifestly a violation of international law if it's established. But what is really going on? So my understanding is that actually the prosecutor wanted indictments for a whole raft of other crimes. And the pretrial chamber said, actually, we can't link the horrors of Bucha and Irpin and Mariupol on the basis of the evidence you've given us to Mr. Putin. The only one we can find a connection to is the children, and that's what we're going to go for. Why did the prosecutor go for Mr. Putin? He went for Mr. Putin precisely because he opposes the creation of a special tribunal for the crime of aggression to target Mr. Putin, because it will deflect from the work of the International Criminal Court. So it's a typical sort of turf war type of situation, very regrettable. So I favor the use of the criminal law to go to the top table. I would go for the crime of aggression and some of the other, frankly, more serious crimes. Now, I do have to draw your attention, and I suspect this will not go down, this does not go down well in the United States. Okay, it goes down fine in the United Kingdom, but I've been in the States for about 4 or 5 days, and I've raised this. There is a huge elephant in the room, okay? And you need to understand this. A lot of countries out there in the global south, in Africa, in South America, and in Asia are keeping a distance from the efforts of various Western countries to support Ukraine. Countries that say, yes, this is horrible, this is terrible, but you, particularly the British and the Americans, are replete with hypocrisy and with double standard because of Iraq. In Britain, you will basically not find any international lawyers who think that what happened in Iraq was lawful. We think it was a manifestly illegal war. We think it was a crime of aggression, and we would not be opposed to the people who decided to perpetrate that war to face exactly the same charges that we say Mr. Putin should charge. I'm not saying Iraq and Ukraine was the same. They're not. They have different motivations. But when we talk about Mr. Blair, it's easier. He was my prime minister. I knew him personally. You can deal with your own president from then. He lied to the British people, he lied to the British Parliament, and he lied to the cabinet. There was no authorization from the UN or international law for that war. It has been a total disaster on the ground. And what it has done, beyond creating exactly the arguments that Mr. Putin is now using, he will not tolerate weapons of mass destruction being placed on the territory of Ukraine in the vicinity of Russia. Sounds like a pretty reasonable argument in the context of Iraq, which was the argument, of course, in Iraq, put by Mr. Blair and Mr. Bush. Apart from giving Mr. Putin's arguments legs, it has totally undermined the ability of Britain and the United States to create a broader coalition in relation to this particular horror. And what is so striking for me is that in Britain, there's a very active debate on this issue, Iraq. In America, no one wants to talk about it. I just get, when I raise it, like, what? And what? This guy's comparing what Bush did to what Putin? How could he possibly do that? I won't do it in relation to Mr. Bush. I will do it in relation to Mr. Blair. I know the facts. I know what happened. You need to understand that in the British context, Tony Blair cannot walk in the streets of London or anywhere else. He cannot show his face in public because of Iraq. You will have noticed he has been totally silent on Iraq because he has no moral authority to raise that issue. And part of the issue here, I think, is a broader issue of double standards, bringing it back, Matt, to the issues that you have to deal with in terms of bioethics, not you personally, obviously. I'm not suggesting for a moment you were involved in any decisions to waterboard any particular individual, but it's essentially the failure to really hold to account the lawyers in the United States, the psychologists in the United States, the medical practitioners who were all participants in the decision to move to waterboarding. Has anyone been held to account? No one's been held to account. Nothing. We've just passed in silence. If we pass in silence ourselves on these acts, How can we go to the rest of the world and say, this is not right, you can't do this? We can't put our hands on our hearts. And that's why the lack of accountability in relation to the events of that period. And I was in New York on September the 11th. I was teaching at NYU Law School. It happened a mile away. It was one of the most horrific days of my life. I lived it. I know how terrible it was. Believe you me. I know many people who were victims then, but also, interestingly, some friends of mine in quite large numbers who have died of cancers within the last 3 or 4 years, who were at the site filming. I mean, the numbers are staggering. I don't know whether you've got those same information in the United States, but French TV reporters, British TV reporters who have become very, very sick in disproportionately large numbers, who were on the ground filming, covering stuff. So I'm acutely aware, but we have to find the wherewithal to not apply a double standard. We have to hold ourselves to the same standard we hold others to, or we undermine our ability.
We are right at
Yeah.
1 o'clock. That was a
Yeah.
beautiful way to end, or a depressing way to end.
Well,
depending on
no,
how
I'm
you
an
look at it.
optimist. I'm a cup half full sort of person.
We are working on those prosecutions.
Oh,
Thank
you
you so
deal
much.
with the medics, I'll deal with the lawyers. Thank you.